The first speaker will present the present book, Family Protection from Legal Perspective. She is Professor Marija DRAŠKIĆ from the Belgrade University. Professor DRAŠKIČ, I give you the floor.
Thank you. Well, good morning to everyone. Dear Professor Dekaš, dear Professor Silecki, dear colleagues and friends. It was honestly a great pleasure for me to read this book dedicated to the family issues concerning protection in the Central European region. The carefully balanced and unbiased selection of topics in this book, its unpretentious and direct yet profound and knowledgeable discourse appears inviting for all interested legal scholars and legal practitioners in and out of region. In fact, the book perfectly reflects comparative legal research, mostly open spirit, lively debates, and the rigorous analysis of the legal systems of Central European countries regarding a great variety of subjects. It is obvious from the most important international human rights treaties, as well as from the constitutions from all over the world, that marriage and the family are global, universal, fundamental human rights values. It is also true that legal norms, which had been relatively undisturbed for centuries, have been discarded or radically altered in the areas of marriage law, the law on marriage-like institutions, divorce law, the legal relationship of parent and child, and the status of illegitimate children. Therefore, plenty of interesting topics can be presented on this occasion. But due to my professional background, actually a part of my professional background and experience, which means that I served as a judge of the Constitutional Court of Serbia from 2007 until 2016, I decided to highlight constitutional lenses through which family protection rules are perceived. In other words, the most valuable decisions of the constitutional courts which the authors presented in this book. But before delving into more nuanced questions, I would just want to add that the status and jurisdiction of the Central European constitutional courts belong to the typical centralized European model of constitutional adjudication. Hence, it is an autonomous and independent state institution which protects the principles of constitutionality and legality, as well as human and minority rights and freedoms. Its rulings are final, enforceable, and binding. It has a wide range of competences, including the abstract review of constitutionality and of conformity with the ratified international treaties, as well as the practice of the individual constitutional complaints. Well, to start with Croatia, three decisions of the Croatian Constitutional Court seem to be very important. The first one refers to the transgender persons. After a 3-year procedure initiated by request of a then 14-year-old child, represented by the mother as the legal guardian, to have a sex change for the purposes of life under another gender identity, the Constitutional Court decided in 2017 that the competent administrative authority violated the applicant's right to a trial within a reasonable time and the right to respect for and legal protection of personal life, in relation to which there is also positive obligation on the part of the state. This change in the base entry of the birth register of the applicant, according to the comment by Professor Aleksandra Korać-Grauvac, leads to the possibility that although entered as a man, he may get pregnant and give birth to a child, creating confusion in civil status registers of newborn children concerning the mother and father fields. Such a case in the Republic of Croatia was still unknown to a professional or broader public. No regulation requires a person wishing to change his or her sex to not be married, which makes it possible for an uneducated civil register to modify the entry on sex in the birth registry of a married person. In that case, it would be possible that two persons of the same sex enter into marriage, which would contravene the public order in view of the constitutional and statutory determination of marriage as a heterosexual union. There is no way to subsequently terminate such a marriage due to the fact that the conditions for the existence of the marriage have to be met only when entering into marriage. It is interesting that the same problem arose in Serbian constitutional practice. Namely, of great importance was the 2010 decision of the Constitutional Court of Serbia on a matter involving an individual sex change. In this case, the applicant of the constitutional complaint was a person who had had sex reassignment surgery, but was not able to change the sex recorded in the administrative register, as the municipal authority declared itself incompetent, citing, of course, the Serbian law on registration of births, which does not provide such possibility. The Serbian Constitutional Court had issued ruling that the municipal administration violated the right to dignity and free development of one's personality, guaranteed by the Article 23 of the Constitution of the Republic of Serbia, as well as the right to respect for private life guaranteed by Article 8 of the European Convention for the Protection of Human Rights and Fundamental Freedoms. Therefore, the court ordered the competent municipal authority to decide on this request for registration of the individual's sex change. After this ruling, Serbia has recently changed the law on civil status register, it was in 2018, in order to permit transgender persons to change their sex according to their new gender identity. Unfortunately, except for the provision that the change of sex may, among other things, be entered into the civil status register on basis of appropriate medical documentation stating that the person has underwent sex reassignment surgery or suitable at least 1 year hormonal treatment, there is no other norm which would specify the conditions a person requiring the change of sex should fulfill, having in mind the extensive provisions on medical and legal requirements in comparative law. For instance, are there any legal impediments to this request, like marriage, citizenship, or age, as well as what are the legal consequences of the legal entry of the change of sex on basis of these provisions, ex nunc, effect only for the future, or retroactive effect ex tunc, since birth. The municipal administrative agencies will therefore still have to cope in practice with the dilemmas the lawmakers have left them with. The next decision of the Croatian Constitutional Court is on non-marital unions. Over time, the effects of recognizing non-marital unions started to extend spontaneously to other legal fields, partially due to the action on the part of the Constitutional Court, which had been extending the effects of the non-marital union to other legal fields. For example, the Constitutional Court, in a 2019 judgment, held that there is no objective and reasonable justification for the difference in tax treatment of non-marital spouses in relation to marital spouses. In the field of pension law, the Constitutional Court held in 2007 that the state should use the Family Act and the Inheritance Act as a framework for the regulation of the right to pension for non-marital widows and widowers, because the Pension Insurance Act at that time did not recognize them as beneficiaries of the aforementioned right to a pension. Finally, as for same-sex unions, the Croatian Same-Sex Partnership Act defined in 2014 the same-sex partnership as the union of family life and named it a life partnership. This act was also supported by the communication of the Constitutional Court on the occasion of the referendum on marriage, which pointed out that a possible amendment to the Constitution based on a provision that the marriage is the union between a woman and a man must not affect by any means further development of the legal framework of the institution of the same-sex union in accordance with the constitutional requirement that anyone in the Republic of Croatia has the right to respect for and legal protection of his or her private and family life and his or her human dignity. After the referendum, it was concluded by the commentators that the introduction of the constitutional definition of the marriage protected only the notion of marriage, in the sense of the institution designed for heterosexual persons, whereas all the effects of the life partnership were virtually equated with the marriage. Anyway, a review of the constitutionality of the Same-Sex Partnership Act is still pending before the Constitutional Court of the Republic of Croatia, having been initiated in 2015. The Hungarian Constitutional Court also emerged in response to the Act on Registered Partnership and declared in the 2008 decision that the establishment of a registered partnership for same-sex persons is not unconstitutional. However, the concrete legislative solution was not in line with the Constitution. Thus, the Act was annulled. The problem was that the legislature did not find any difference between the registered partnership between same-sex and heterosexual persons and applied only a general reference rule to marriage. With this, the legal institutions of marriage and registered partnerships between same-sex and heterosexual persons were made uniform. Therefore, the Constitutional Court instructed the legislature to maintain a distance between marriage and cohabitation among men and women, and to distinguish between marriage and registered same-sex cohabitation. This order of the Constitutional Court has been applied in legislation, which means, according to Professor Edith Sapi, that marriage enjoys primacy in the Hungarian legal system because registered partnerships have similar legal effects. There are some differences in the legal effects of marriage and registered partnerships, such as that registered partners cannot adopt a child jointly and cannot participate in an assisted reproduction procedure. In another 1995 decision of the Constitutional Court of Hungary, emphasized that the long-term cohabitation of two persons can achieve such values that they can claim legal recognition regardless of their gender, based on equal consideration of the personal dignity of the individuals involved. In the 2012 decision, the Supreme Court of the Slovak Republic held that the intention of the legislator was to allow the establishment of marriage exclusively to persons of different sex and not of the same sex. In this case, two men turned to the Supreme Court because they were not able to enter into marriage and claimed that their fundamental constitutional rights were violated. The Supreme Court of the Slovak Republic, however, ruled that their rights were not violated. In fact, the court put it, I would say somewhat cynically, that they were allowed to marry, but in accordance with the Constitution of the Slovak Republic and the Family Act. Professor Lila Gavrajova therefore concluded that nevertheless, the process of Europeanization of family law, as well as current societal changes, seems to be an inexhaustible source of not only inspiration, but also conflicting and controversial opinions in society, as family law is the area that affects the most intimate area of every person's life. Registered partners are not allowed to jointly adopt a minor child or become foster parents of minors in the Czech Republic, as only married couples can do it. However, the discriminatory provision that prohibited a single adoption by one of the partners of a registered partnership was cancelled by the 2016 decision of the Constitutional Court of the Czech Republic. The Constitutional Court found the provision discriminatory, as it indicated that registration is in itself an obstacle in the course of adopting a minor child by one of the registered partners. As regards paternity, the Czech legislation recognizes three traditional legal presumptions in establishing legal parenthood. Thus, the first presumption is in favor of the mother's husband if the child is born in wedlock or within 300 days since its termination. The second presumption respects the autonomy or will of the child's parents and is in favor of the man who has stated, together with the child's mother, that he is the father of the child. The third presumption, I would say unique in comparative law, is based on sexual intercourse in the critical period. The father of an unmarried woman's child is considered to be the man who had sex with her within the period of 160 days till birth and within the period of not exceeding 300 days before birth, unless his fatherhood is excluded by serious reasons. As for the third presumption, Professor Zdenka Kraljičkova assessed that conservatism prevailed, even though the Constitutional Court, in a 2008 decision, and several family law experts concluded that its traditional basis, namely sexual intercourse within the so-called critical period, was antiquated by the revolutionary development of genetics, the DNA test in the first place. The newest development, inspired by the case law before the European Court of Human Rights in cases Pavlik versus Slovakia in 2007 judgment and Novotny versus the Czech Republic in 2018 judgment, forced the Czech legislature to allow men designated by the court to be legal fathers under the third presumption of paternity when DNA tests did not exist, to reopen proceedings and reverse the effects of res judicata. Interestingly enough, again the same happened to Serbia, although this third presumption does not exist in Serbian law. Namely, in a recent 2020 judgment case of Boljević versus Serbia, the European Court concluded that Article 8 of the Convention has been violated because the applicant and his mother failed in the request in 2012 for the reopening of the proceedings from 1972, when the paternity of his mother's husband was contested before the then Supreme Court of Vojvodina. The European Court reaffirmed its position that denying the right of a child to know who his real father was and denying him access to modern DNA testing methods in order to find out was, in the applicant's view, but also in the court's view, unacceptable from the standpoint of the Convention. In spite of the fact that, according to the Serbian Civil Procedure Act, in any event, once 5 years had elapsed after the impugned decision had become final, no reopening could be sought, and therefore this judgment became res judicata. On the other hand, when paternity had been established by a judicial declaration and the judgment had come into legal force, the law does not provide for any possibility to challenge it. But the court also notes that after the expiry of the deadline in question, domestic law did not therefore allow for the relevant elements of the applicant's specific situation to be taken into account. This sentence, therefore, sounds, as the court points out, that by Article 46 of the Convention, that the judgment in which the court finds a breach imposes on the respondent state a legal obligation not just to pay those concerned the sums awarded by way of just satisfaction, but also to choose, subject to supervision by the Committee of Ministers, the general and/or, if appropriate, individual measures to be adopted in their domestic legal order to put an end to the violation found by the court and to redress, so far as possible, the effects. Therefore, I am eager to find out from my Czech colleague what was the proper response of the Czech legislation to the aforementioned decision of the European Court. Many of the Polish Constitutional Tribunal's important judgments have concerned family issues too. Some most relevant examples follow. Article 71 of the Polish Constitution obliges the state to enact a social and economic policy that takes into account the good of the family, especially those families in a difficult financial or social situation. It also spells out that the state's duty to offer special assistance to families with many children and single-parent families, as well as providing support to mothers before and after giving birth. With reference to these regulations, the Constitutional Tribunal of the Republic of Poland ruled that provisions of the Act of 2002 on family benefits concerning an allowance paid to single parents were inconsistent with the Constitution. This social benefit was paid to unmarried, single, widowed, divorced, or separated persons who raised the child with the child's father or mother. At the same time, no provision was introduced to exclude cohabiting couples with children from being eligible. As a result, those cohabiting had an advantage in terms of access to benefits over married spouses raising children together. Thus, this regulation, evaluated by the Constitutional Tribunal, serves as an example of an unwise social law with that weakened family ties. Another Constitutional Tribunal decision, which was provoked a heated debate and stirred up a tumult of emotions in Poland, creating social tensions and political dispute over the condition for the admissibility of abortion, was its 1997 judgment, where the Constitutional Tribunal took the stand that the Constitution should protect human life from conception. It enumerates, however, 3 exceptional circumstances that allow for the termination of pregnancy. Under the Polish law, abortion was permissible if the conception of a child was a consequence of a punishable act, when the pregnancy endangered the mother's health and life, and if the child was permanently damaged. Finally, as Professor Marek Andrzejewski informed us in its 2020 judgment, the Constitutional Tribunal ruled that the admissibility of performing abortion on the basis of the last premise is inconsistent with the Constitution, as it discriminates against persons with disabilities. Unfortunately, we all witnessed last week the tens of thousands of demonstrators took to the streets in Poland after the death of a 30-year-old pregnant woman. Her family said the doctors at the hospital where she died had refused to terminate her 22-week pregnancy, although her fetus lacked enough amniotic fluid to survive, attributing it to the rules in effect limiting the possibility of a legal abortion after this 2020 judgment of the Constitutional Tribunal. In the context of non-discrimination based on disability, in its decision on the notion of the Ombudsman for a declaration of non-compliance of Article 12 of Family and Guardianship Code with Article 47 of the Constitution and Article 23 of the United Nations Convention on the Rights of Persons with Disabilities, the Constitutional Tribunal disagreed with the applicant. It took the position that prohibiting a person suffering from significant mental disability resulting from a serious mental illness at an advanced stage, or from a profound intellectual disability to get married, to which the aforementioned provision refers, does not discriminate against people with mental illness and/or disabilities. From the point of view of equality with regard to the right to marry, persons with mental disabilities, in the eyes of the Polish Constitutional Tribunal, are considered to be in a different position from those who are intellectually sound. Back to Serbia, Professor Gordana Kovaček-Stanić has also noted very important decision by the Constitutional Court related to the protection against domestic violence. Namely, the initiative for assessment of the unconstitutionality of the provision of the Family Act on determining the measure for temporary eviction of the perpetrator from family apartment was dismissed. The Constitutional Court delivered its position on the constitutionality of the provisions of the Family Act, rejecting to determine that the measure for temporary eviction of the perpetrator from a family apartment in case of domestic violence is not in accordance with the constitutionally guaranteed right to property. The Constitutional Court grounded its decision primarily on a premise that it was not a restriction of property rights, but a temporary restriction of the manner of using the property that is permitted by the Constitution in order to protect the psychological integrity of the victim of domestic violence, and thus also for the public interest protection. On the other hand, the Constitutional Court also founded this decision on the famous judgment of the European Court of Human Rights in 1995 case of Scolo versus Italy, as well as 2009 case of ES and others versus Slovakia, which confirmed the right to states to enact such laws as they deem necessary to control the use of property in accordance with the general interest. Such laws are especially common in the field of housing, which in our modern societies is a central concern of social and economic policies. Finally, the last chapter of the book is devoted to Slovenian law. According to the Constitution of the Republic of Slovenia, legal relations within the family shall be regulated by a law. The main legal act that regulates family relations is the new family code. Professor Suzana Kraljic assessed that family policy in Slovenia is based on an integral approach. The family code provides a broader definition of the family as the living community of the child, regardless of the child's age, with both or one parent or with another adult, provided that the adult person cares for the child and has certain obligations and rights towards the child. Family is thus recognized as an important social institution that enjoys special protection. The Civil Unions Act was also adopted in 2016, which brought about the equalization of partners in a civil union with spouses. At the same time, Civil Unions Act did not grant same-sex partners rights that are certainly among the most desirable, namely the right to marry and the right to joint adoption of a child in Slovenia, nor were they given the right to undergo in vitro fertilization procedures in Slovenia. Therefore, there is a clear distinction between marriage, which under the family code can be entered into by two persons of different sexes, and civil unions, which can be entered into by two persons of the same sex, that is to say, two women or two men. Family Code and Civil Unions Act have in common that both legal acts are based on the principle of monogamy. Thank you for your attention. I apologize for slightly exceeding the set time. Thank you.
Thank you.